SJC-12821, Tyrone Garden v. Commonwealth.
Good morning, Mr. Garden. Good morning, Your Honor. You may proceed. Why don't you, so where's your microphone?
Yes, sir.
It's there. Is it easier for you to speak into it if you're sitting as opposed to standing?
I can try to pull it right here.
Yeah, that's better. That's better. Okay, I think it's best if you sit because the microphone will be closer to your mouth if you do that. So why don't you then address us? You have 10 minutes, sir.
Yes, Your Honor, on February the 1st, 2012, my guilty plea was not knowingly involuntary because it was based upon ineffective assistance from my lawyer. Prior to my guilty plea, I can only tell the court that for almost 5 years I stood by the fact that the statute of limitations in this case had expired and that I only took the plea because my attorney had convinced me that the case was hopeless. I believe that if he had did his homework, in the words of my appeal attorney, Eva Jolison, that he would have seen that the Perella case was a mirror image of my case. I arrived on February the 1st, and my attorney told me that the statute of limitations was completely dead, and I needed to plead guilty to avoid a possible life sentence. So when the judge told me that I was waiving my statute of limitations argument, I was relying on my lawyer's inaccurate advice, and my statute of limitations argument was completely dead, what my lawyer had told me. We all know my lawyer's advice was wrong because at the time of my guilty plea, the Perella case was before this court. On August 24, 2011, the Commonwealth filed its Perella brief. October 27, 2011, the Perella case was transferred to this court. On January 27, 2012, the court requested amicus brief regarding Perella. February the 1st, the same day as my plea, the Commonwealth filed its reply brief in the Perella case. I am not an attorney, so I had no way of knowing about this case. But if I had known the Perella case was on appeal in this court, I never would have pleaded guilty. My lawyer was ineffective by telling me my had no hope of success when the court was considering the same legal issues in Perella. Under these circumstances, there is no way that my waiver of my statute of limitations argument was knowingly and voluntarily. A lawyer was ineffective by telling me the statute of limitations argument had no hope when this court was considering the Perella issue. Under these circumstances, there is no way my waiver of my statute of limitations argument was knowingly and telling. I respectfully request this honorable court to review this case anew, confirming the facts in this case, and consider all of its arguments. I only ask for the relief I had originally sought, dismissal of the indictment because the statute of limitation had expired and setting aside the conviction obtained from it.
Okay, thank you, sir. If there are no questions, and I don't hear any, I'll turn to Ms. Lazar and ask whether you wish to respond.
Good morning, Your Honor. Yes, briefly.
Okay, Mr. Garden, can you hear Ms. Lazar?
Yes.
Okay.
Yes, sir.
I would ask that you speak up so Mr. Garden can certainly
I will. Ellen Lazar for the Commonwealth. The single justice correctly exercised his discretion to deny the defendant's petition for relief first and foremost because the defendant had and pursued adequate alternative avenues by which to seek the relief that he requested when he filed a prior petition for relief in 2011, which was denied, and by moving to withdraw his guilty plea. To the extent that this current petition sought reconsideration of the 2011 petition, that was untimely. And the fact that the defendant has not obtained relief through these other alternative avenues does not mean that he did not have an adequate opportunity to do so. For those reasons, the Commonwealth would ask this court to affirm the order denying the defendant's petition.
Okay, thank you. We shall take the matter under advisement. Thank you.